Consumer Counterpoint, your video cast that talks about consumer issues related to class actions, way to mitigate against those risks. I'm Christine Argentine, a partner in our Seyfarth Shaw office in Chicago. Will my co-host introduce himself?
Yeah, my name is Paul Yvonik, and I'm a senior associate in the Chicago office.
Great. And so today we are going to cover GIPA. So, Paul, why don't you define that for us and tell us a little bit about that statute?
Yeah, so today we're going to talk about the Illinois Genetic Information Privacy Act, and that was a statute that was enacted by the Illinois legislature in 1998. You know, at its core, it was designed to protect individuals against discrimination with respect to genetic information and their genetic makeup. It protects against employment, and also it protected really against like insurance companies discriminating against individuals based on what they disclose in their genetic questionnaires.
So an older statute.
Yes.
When did we start seeing litigation under this statute?
Yeah, so kind of like the Illinois Biometric Information Privacy Act, it was one of those statutes been sitting out there for a long time, never really utilized, never really litigated. I would say around 2022, we started seeing some cases pop up here and there. It's almost like as you kind of saw the dip in like maybe the BIPA filings, the biometric cases, it was, let's find another private right of action, attorney's fee provision that we can jump onto. And as we discuss the statute, I think we'll see some similarities between the Biometric Privacy and the Genetic Information Privacy Act. So, GIPA was one of the first of its kind to really protect against, genetic information in the U.S. And then in 2008, GIPA was amended. So the same year that BIPA was enacted, it was amended to mirror closely to GINA, the Genetic Information Non-Discrimination Act at the federal level. Again, the idea was to prevent discrimination because of someone's genetic makeup or the information that they disclose on a genetic basis. And so in 2022-ish, we started seeing some of these cases first getting filed, really in the employment section. So we see medical questionnaires, post-offer, pre-employment medical examinations, where they might be asking certain questions related to someone's health. Sometimes it's verbal. Oftentimes we are also seeing like written questionnaires. And in some cases we're seeing it where these questions are being asked that are required by under other federal and state requirements, such as OSHA and stuff. And so, some of those cases, we haven't seen them fully develop, but certainly not as clean as BIPA cases, I would say, with respect to, we talked about it in a prior episode. Really a lot of these cases we saw in BIPA were no notice, no policy. It was kind of a black and white issue. If you didn't have the written consent, it's hard to say that you had written consent.
Yeah. So what are the causes of action we're seeing? What are the claims that are being made saying that a company is violating GIPA?
Yeah, so the big one we're seeing is the solicitation of genetic information as a condition of employment.
Okay.
And so, as again, going back to kind of this, post-offer pre-employment, examination or health questionnaire, do you have a history of diabetes or heart condition? Does your family have one? Those are the kind of questions that plaintiffs have been saying. Questions like that, and even questions not even close to that, but very, different, are just saying that is a solicitation as a condition of employment, such that if I don't answer those questions, I might not get the job. And so that's really where we saw a lot of it. We saw some cases very early on that just had these questionnaires that asked these questions very explicitly. And then, as time went on, we started seeing more, it was, a verbal question by a physician in a post-offer pre-employment evaluation. And so, we're starting to see, and I think it's been very telling, we haven't seen as many GIPA cases filed at the rate that we saw BIPA.
Sure.
Maybe a couple hundred at best with GIPA, as opposed to the 1,000 plus that we've seen under BIPA. That's going back to the kind of the black and white in a lot of cases, the low-hanging fruit that we saw filed very early on in BIPA. as opposed to these Genetic Information Privacy Act cases that are a little bit more complex. And I think we're seeing that in the early stages of discovery, even discussing with the plaintiff and the judge, the practicalities or the concerns of what we're seeing for class certification briefing. I mean, we've seen some judges already kind of tip their hand in ways of like, well, that seems a little bit more complex than what these BIPA cases we're seeing.
Okay. And so you said there's an attorney's fee provision.
Yes.
Is there a statutory damage provision in there?
Yeah, so if you look at the damages provision of GIPA, you'll see that it looks nearly identical to BIPA. And so obviously with the Genetic Information Privacy Act being a little bit earlier, we can maybe conclude that BIPA was, pulled some language from GIPA. And so there is this, again, like BIPA, a negligent and a reckless or intentional violation of the statute. And where BIPA is $1,000 or $5,000, whether it's negligent or reckless or intentional, GIPA is $2,500 per negligent violation and $15,000 per reckless or intentional violation. Yes. So it's interesting, and there is the attorney's fee provision. I think we can pull a lot of what we've learned in the litigation under BIPA for the last several years to make some conclusions or assumptions right now. For example, because the damages provision is identical from BIPA to GIPA, going back to the Coughlin versus White Castle decision that held that the BIPA damages provision implies that there is discretionary damages. That's going to be the same thing here.
Sure.
I think there's going to be a hard argument to say it's not. It's the same language, same idea.
And with the $15,000, that's a significant amount of money that if you go per violation can tick up very quickly.
It is. And so, but the one thing you have to remember is the BIPA statute was amended last year to make it clear that like a single violation for the same capture collection is a single violation. We don't have that language in GIPA yet, but I can imagine that when push comes to shove, and in an argument just like we saw in White Castle where they said, well, hey, if every scan's a violation, we have $17 billion in exposure. Well, that was on a $5,000 per violation. Now, if it's $15,000, now the difference is there too is we're talking about each scan being a violation. Could be 2, could be 4 a day, as opposed to this Genetic Information Privacy Act where the solicitation of genetic information as a condition of employment probably only happens once.
Sure.
And so it might not really become this like per violation, multiple violations, because it really probably only happens once.
Yeah. So I know when we were talking about BIPA, we talked about what does a negligent violation mean versus what does an intentional violation mean. And in BIPA, I think you said that's not really resolved yet under the case law. How about under GIPA?
Yeah, it's also not resolved.
Okay.
I mean, and also we just haven't had cases go the distance because these cases were filed in 2022, 2023. We're talking about, still in discovery, still very much in class certification phase for a lot of these cases. We've seen some favorable decisions for the defense. I think that, one thing that we're seeing in a lot of the GIPA cases that we haven't really seen in other cases is like there's, or like in BIPA, there's a GINA disclosure. So like we've seen some defendants have on these questionnaires that might not expressly ask for genetic information, but plaintiffs are trying to argue, well, it could imply or it could insinuate genetic information. We also have this GINA disclosure that we're seeing in a lot of these cases saying, well, wait a minute. We have a disclosure here from the federal level saying, do not provide us with genetic information, even if you think that this question might call for it. We're not asking for it. And so, again, it's just the complexity I think we're going to start seeing at the class certification level, especially when we start talking about the allegations we're seeing of like, oh, these questions are, being made, verbally during, an examination. Well, that's... Unless you can show that question's part of a pattern and practice of a physician, it starts getting into more of an individualized inquiry.
Real classification issue.
Yeah, so I think those are kind of some real differences, and maybe why we haven't been seeing as much in the terms of like filings as compared to BIPA. I mean, it just seems like there's a lot of similarities. We would expect to see it, but I think these cases just haven't been as smooth for the plaintiffs, at least from the decisions we've been seeing.
Yeah. Okay. So we're obviously a consumer
Yep.
podcast. Has GIPA, right? You've said it's mostly in the employment context. Has it expanded into the consumer space at all?
It has, and I would say in a very creative way. And we've been seeing this, in some of these cases, kind of GIPA being married with another topic we've discussed, which is the pixel tracking and the cookies, and so there's these cases out there, with DNA testing companies or genetic companies. Where users are uploading their genetic information, and if there's a pixel firing at the same time, then it's disclosing, and plaintiffs have alleged, that's identifying someone has undergone a genetic test, and that's kind of one portion of the GIPA statute as well, is disclosure without consent of someone who's undergoing a genetic test.
Okay.
That's very much up for debate still with the courts, and so that's kind of one side that we're really seeing. That again, we're seeing also insurance companies getting sued previously. For the same reason that we kind of discussed for this discrimination side, not necessarily employment, more of just health insurance and coverage issues. So.
Yeah. So when we're talking about kind of that combination of the pixel cases with the GIPA cases, so essentially we're saying the claims are that the genetic information or the fact that someone's taken a genetic test is being unknowingly shared with third parties.
Correct.
Okay.
Correct. And that's exactly it. And so, obviously, looking at the language closely, there's probably some arguments against that. It's a prior test being uploaded. And so, that's obviously something we're going to have to see how the courts, address that. But that is exactly it. So it's not just this, disclosing of genetic information, because it's really just disclosing, that someone uploaded a DNA, kit, it might be, and so that's I think the difference. And so it's a little bit different. It's not, you have to take a couple steps to get to how this claim is being alleged.
Sure.
It's not as clean as these employment cases we're seeing. I think it's a very creative, and we'll see how the courts react to it, but it's creative at best.
Yeah. And so, Illinois has kind of been on the forefront with BIPA, with GIPA. Have we seen other states, privacy? We've seen states passing privacy laws the last couple of years very consistently. Do we have other states that are looking specifically at genetic information protections?
Yeah, there are a few other states, and obviously with Illinois, I think just with this private right of action, these statutory damages, and I think just the language, I think everyone felt very comfortable with BIPA and said, all right, well the damages provision seems pretty comfortable here, so why don't we just stay with it? But we are seeing other states, I think Alaska, New Hampshire, Oregon, New Mexico have genetic privacy, specific genetic privacy statutes on the books as well, that we're seeing claims being asserted as well. Again, because these cases have been, are creative and they're relatively new, we haven't seen courts make any real rulings on, the viability of some of these, cases, especially with some of these damages provisions that are even higher than what we're seeing under the Illinois Genetic Information Privacy Act. So, time will tell on that part. The decisions that we've been seeing have been, the favorable ones for the defendants we've been seeing have been more in the employment context, and just, we've seen where, if a plaintiff, is being asked allegedly about genetic information and refuses to provide that information but is still hired, well, then the courts have held, well, maybe that's not actually a condition of employment.
Sure.
You were hired,
right,
even though you rejected, answering those questions. So we saw a decision come out like that. We also saw where, genetic information is being solicited for furtherance of an employment wellness program. Well, that is preempted by ERISA, and therefore, courts have held like that. That's not a claim either. So those are kind of some of the bigger wins we've seen over the last year and a half, 2 years. But on the consumer side, we haven't really seen it, because these consumer cases under GIPA and other state genetic information privacy statutes are relatively new.
Yeah.
So we're still really much in the motion to dismiss phase.
Yeah, and I would imagine with BIPA having kind of a couple years worth of litigation already, these GIPA cases are easier to kind of fight in Illinois and make similar comparisons, whereas these other states don't necessarily have case law already established, even in a similar area that can be drawn from.
Right, and so I mean, our hope is that the courts look at that with a fresh set of eyes and not just assume that, well, if BIPA held this and we can apply it to GIPA, then maybe we can just apply similar analysis of those decisions to other state state privacy claims, and especially genetic. So I mean, while we are able to pull some similarities from BIPA to GIPA, I think that the defense bar is still taking a second shot at some arguments under GIPA, just to say, all right, well, we can see why the court might have came to this conclusion under BIPA. It doesn't mean that it needs to come to this conclusion under GIPA. I mean, I think there's some that, again, that are just going to be inevitable. Damages are discretionary. I mean, the statutory language is identical, nearly identical. The other part of it, just being that, so the damages being identical, whether or not there's discretion, there is. So I think that's what we're going to be looking at as those types of similarities that we probably just can't get around. Oh, statute of limitations is another one. That's the one I was looking for. Statute of limitations, because the statute, just like BIPA, does not have it does not expressly state a lesser statute of limitations or any specific statute of limitations. It then also has the same catch-all 5-year statute of limitations period. I don't think we're going to be able to get around that one. Tim's held that part, and Tim's versus Black Horse Carriers.
Yeah. Okay. So any company that is touching or has any information related to genetic information or collection of genetic information needs to be aware of this statute.
Absolutely.
And it sounds like other statutes, and obviously, we'll keep you posted on this podcast about other statutes, and as we see developments in the law, I'm sure we'll come back with new episodes on those.
Sounds good. Yeah.
Okay.
Thank you.